To understand the role of Sharia in secular or non-Muslim majority countries, it's essential to start with the foundation of national law. In nearly every country outside the Islamic world, the constitution or core legal system, whether based on civil law, common law, or a secular charter, takes precedence over any religious legal tradition. Sharia, the Islamic framework for ethical and religious conduct, is fundamentally a set of principles guiding personal religious practice for Muslims. Its application to public law and broader society only occurs where a country's statutes or constitution explicitly permit it. Contrary to popular misconceptions, Sharia does not automatically replace or override national law in places like the United States, Canada, most of Europe, or other secular nations. The supremacy of national law is a cornerstone of these societies, ensuring that legal rules are rooted in democratic processes and apply equally to all citizens, regardless of their faith. Where Sharia has any legal force, it is almost always confined to very specific, voluntary contexts, such as family law or inheritance matters for Muslims, and only when the state has chosen to allow it. Even then, its reach is limited and carefully circumscribed by statutory and constitutional boundaries. Take for example, the distinction between private religious practice and public law. Much of what is commonly referred to as Sharia, daily prayers, fasting during Ramadan, dietary restrictions, charitable giving, is simply religious observance. In most countries, these practices are protected under laws guaranteeing religious freedom, but they do not create a parallel legal system. Courts in secular countries will apply national statutes when those statutes govern an issue, regardless of the party's faith. A Muslim employee observing prayer breaks at work is exercising a personal religious right, not invoking an alternate legal order. Sometimes, jurisdictions allow faith-based arbitration, where consenting adults resolve family or business disputes under religious law. This is permitted in parts of the UK, Canada, and elsewhere. However, even these religious tribunals cannot override mandatory public laws, such as criminal statutes, anti-discrimination rules, or core family law protections. For instance, a faith-based arbitration decision about divorce or inheritance must comply with national law limits and is subject to review by secular courts. The idea is that religious arbitration supplements, but never supplants, the authority of the state. There are limited examples where Sharia has broader legal force, but these are the result of explicit legislative choices. In some Muslim-majority countries, or regions within those countries, Sharia is incorporated into family law, inheritance, or other aspects of civil law for Muslims. Aceh, Indonesia, is a notable case where regional law has extended Sharia-based rules beyond Muslims, sometimes affecting non-Muslim minorities. These are specific, localized phenomena, not universal norms. In most places, including countries with large Muslim populations like India and Nigeria, Sharia operates in a carefully defined sphere and does not impose its rules on the general population. So why, then, does the idea of Sharia law provoke such intense debate and fear in some Western political circles? This brings us to the concept of weaponizing Sharia, the deliberate use of Sharia as a scare tactic by politicians or activists to mobilize voters, block Muslim projects, or justify restrictive laws. The Texas Epic City dispute is a vivid, recent example. In 2023, a Muslim-led development project known as Epic City in Texas became the focus of intense controversy. Governor Greg Abbott publicly criticized the planned community, calling for laws to block so-called Sharia compounds, and supporting legislation and investigations aimed specifically at the project. This rhetoric sparked widespread media coverage and a swift backlash from Muslim civil rights organizations, including the Council on American Islamic Relations, CAIR. They condemned the governor's statements as fear-mongering and discriminatory, arguing that they stigmatized ordinary religious practice and chilled the freedom of Muslim communities to pursue charitable or business projects. It's important to separate the reality from the political narrative. U.S. law, at both the federal and state levels, robustly protects religious freedom and forbids the establishment of a separate legal system that overrides American criminal or civil law. The recent measures in Texas did not actually create a ban on Sharia. They targeted specific business structures and real estate contracts rather than establishing a parallel system of law. Yet, the public messaging framed these actions as a broad ban to appeal to voters' anxieties about Sharia taking root in America. This strategy, weaponizing Sharia for political gain, has real consequences. It fuels the spread of Islamophobia and social exclusion, as documented by CARE and other advocacy groups. Muslim communities see their institutions subjected to scrutiny and regulation that similar non-Muslim projects do not face, a clear example of unequal enforcement. The fear generated by such rhetoric can discourage community development, religious life, and charitable work, as Muslims worry that even routine initiatives may be targeted or misrepresented. The effects go beyond community chill. When Sharia is weaponized as a political tool, it undermines constitutional protections and the broader principles of religious freedom and equality. It blurs the line between personal religious practice and public law, confusing voters and policymakers alike about what Sharia actually is and isn't. This tactic also risks fostering a climate in which legitimate Muslim-led initiatives, whether schools, mosques, or community centers, face additional hurdles, regulatory delays, or hostile public opinion. There is a parallel phenomenon in some Muslim-majority states where Sharia-based laws have been used to restrict the rights of minorities. In Aceh, Indonesia, for example, regional laws have extended Sharia rules to non-Muslims, sometimes resulting in penalties or constraints that go far beyond religious practice. This is a distinct issue rooted in state law choices rather than political rhetoric, but it shows how religious law can be wielded to exclude or punish minority groups. Given the real harms of weaponizing Sharia, stigmatization, unequal enforcement, and legal chill, what can communities and defenders do in response? The playbook involves several practical strategies. First, legal challenges are essential. Muslim communities and their allies can invoke constitutional protections, including equal protection and religious freedom, to challenge selective enforcement or discriminatory regulations. Courts have repeatedly affirmed that religious practices are protected, but must operate within the framework of national law. Second, public education is critical. Explaining what Sharia actually covers and what it doesn't helps reduce fear-mongering and correct misconceptions. Civic organizations, interfaith groups, and educators can clarify that Sharia, for most Muslims, is a guide to personal conduct, not an alternative legal system. This distinction is vital for fostering understanding and reducing the impact of scare tactics. Third, coalition building strengthens the response. By partnering with other faith communities and civil rights organizations, Muslim groups can present a united front against discriminatory policies. Coalitions like CARE and local interfaith alliances have proven effective in mobilizing public opinion, engaging with media, and lobbying lawmakers to reject exclusionary measures. Fourth, transparency and compliance matter. Community projects should meet the same regulatory and disclosure standards as any other development, ensuring there is no basis for claims of secrecy or lawbreaking. By adhering to established rules and communicating openly with local authorities, Muslim-led initiatives can demonstrate their commitment to lawful conduct and civic engagement. Ultimately, the bottom line is clear. Legally, Sharia does not override or replace national law in secular or non-Muslim majority countries. Religious practices are protected, but always subject to the Constitution and statutory law. Politically, Sharia is often invoked as a scare word to justify targeting Muslim communities. Texas's Epic City controversy is a recent concrete example of how this strategy works and how it provokes pushback. Understanding the reality behind the rhetoric is crucial for citizens, policymakers, and community leaders alike. By focusing on facts, upholding constitutional principles, and fostering dialogue, societies can reject fear-mongering and promote a more inclusive, accurate view of religious practice and the role of law.